Thank you so much for your time tonight. Perhaps let's go a few steps back when it comes to this case, and let's talk about the history of where it stems from. And it really goes back to Zimbabwe and the land expropriation without compensation and the land grabs that were taking place there, and the complaint being laid by white farmers.
Well, I think there's some applicants who were interested in the relief that the tribunal might be able to give relevant to that particular dispute. So what the tribunal does, it allowed for access to justice to anyone in Southern Africa where there's a dispute between the state and individual parties. But however, this matter was specifically launched by the Law Society of South Africa, supported by civil society in South Africa, regarding South Africans' access to justice, and not necessarily because of what is happening in other countries and their rule of law issues. And if you read through the judgment and what the Concord says, they really stress the point that it is really about our constitution, our rights, and the way in which the executive has to interact with their powers in line with our constitution. So it has not as much as is being played out to do with what's happening in foreign countries.
Okay, so basically you're saying that you needed a decision made on the former president's participation in the suspension of that tribunal in terms of what SADC at the time had agreed to.
Yes. So the international politics do involve what's happened in other countries. So the SADC tribunal could deal with matters in other countries, and as South Africans here, anyone in South Africa who had a dispute could approach that court. And our constitution says we have access to justice. And what the president then did was he went and signed a protocol with other leaders, which then suspended and purported to disband the SADC tribunal. In doing so, he is limiting the right to access to justice for South Africans and also obviously for other nations across the SADC region. And that suspension was obviously unlawful, irrational, and not consistent with the rule of law, and more importantly, not consistent with the Constitution and the way the president has to exercise his powers.
What then becomes the role of the kind of relations and the allegiances that are built, especially within the region? Of course, had he perhaps not signed that agreement, there would have been potential fallout in the region, political pressure. So in terms of the overall approach, as you made your argument for this case, what consideration did you have to that?
Yes, and I think this is something that the court did actually address in its judgment. The issue is that ultimately we're a constitutional democracy. You know, we're not a monarchy. And therefore, any person who acts on behalf of South Africa has to act with regards to our constitution and uphold those values in the Constitution. So even in the way we conduct our foreign affairs, we cannot conduct our foreign affairs in a way that is ignorant of what our Bill of Rights and what South Africans' legacy is. And even if there's disagreement with foreign parties, that's part of foreign policy. Countries are not always in direct agreement. But what the Constitution is saying is that the executive, when it's interacting with the international order, has to act in line with the Constitution and represent South Africa whilst looking at our Bill of Rights and not in an authoritarian way. Yeah.
And of course, this takes us also back to decisions that we saw around the Omar al-Bashir matter.
Yes.
You know, they may be different, but certainly they're along the same stream in terms of what we're consistent about, where, you know, our own local laws and the international laws that we have subscribed to. Does this ruling have any implications, though, for the future of the tribunal? Does it provide any kind of footing for that tribunal to be resurrected going forward?
Okay, so I'll address both points. And I think the parallel to Omar al-Bashir is a good one. Because before the turn 2010, essentially, South Africa understood what its obligations were. If you know, the Rome Statute is part of South African law. There's an implementing act which makes us those obligations binding to us. And then our foreign policy was very clear in letting those who were indicted know that they could not come to South Africa. It does not mean that you cannot engage people in a foreign area. But these laws are important because what you're saying is there are certain crimes of an international order that if the international community ignores and does not show some sort of response to, they then perpetuate. And that affects not just those regions, but also South Africa as a nation which takes in refugees, a nation which has international trade. It is in the international orders and South Africa's interest that there is stability in its region and that there is rule of law past just our borders. Now, the second issue is that with the tribunal the way it is now, the court says that the president has to withdraw his signature, and therefore that protocol which was signed now will not have South Africa's endorsement. What we know is that there are similar challenges that are taking place in other SADC countries, and there is this push to have their judiciaries also rule on whether or not the other presidents who did put in this protocol did so lawfully. And if you look at the decision, it not just challenges the president in terms of him acting ultra vires outside of his power in terms of the Constitution, but that protocol which disbanded and suspended the tribunal was unlawful in terms of the SADC treaty that empowered them. So the hope, obviously, is that with the momentum of different challenges, eventually we might see a situation where the SADC tribunal returns, but there's still a lot of work to do before that happens.
All right, well, let's leave it there for tonight. We've run out of time for our interview. Wayne Ngube, Head of Litigation at Lawyers for Human Rights.